Back on the record, this is the people of the state of Colorado versus James Egan Holmes, case number 12 CR 1522. The record should reflect that Mr. Holmes is present with his attorneys and the prosecutors are present as well. During the break, I had an opportunity to quickly review the people's slides and to consider the objections to the slides and the responses to the objections. I want the record to reflect again that this was brought up at the last minute, and as the jury has been waiting all morning, I'm doing the best I can given the little time that the attorneys have allowed the court for these objections and responses. In terms of the global objections, all of the global objections are overruled. Slides are visual aids that the attorneys can use. Both sides have used slides in this trial. Both sides have used them, for example, in closing argument, and I believe that both sides used them as well with respect to witnesses. So the global objection to the use of slides, in my view, lacks merit. There were some global objections that were more detailed than that, and it had to do with the color of the slides. I actually like the color. I like that they're black and white. I think that's as neutral as it gets. I think where the case law sometimes has issues is when attorneys use red, which is the color of blood, or perhaps some other color that may be improper in some way. For the most part, these are black and white. I think there's some yellow in some of the font. None of that color bothers me. And I actually like that the people made them black and white because I think that's the most neutral, those are the most neutral colors. In terms of the size of the font, as you attorneys know by now, I like large font. I don't use 12 font as you do in all your pleadings. I use 14 font. My eyes get tired when I'm reading small font. But secondly, I just think it makes it easier to read and to understand things. In this case, the font is appropriate because the screens in the courtroom are far away from the jury. And we have all observed throughout the trial, at times the jury is squinting to try to see what is being shown on a particular screen. And that's because the font of some exhibits is small. And both sides have used a method to call out particular portions of writing in exhibits that have been admitted and shown to the jury so that the jury can actually see what's on the screen. So the large font doesn't bother me. And in terms of the content and the picture and the choice of words, I'm going to address those specifically with respect to the objections identified by Ms. Brady. And so let me go through those now. By the way, before I proceed with the specific objections, let me just state that I am mindful that in this phase of the proceedings, the prosecution is the only party that has the burden of proof. And the prosecution's burden of proof is high. It's the highest burden of proof available under the law, as Mr. Orman indicated. The people have to prove beyond a reasonable doubt each and every element of at least one of the aggravating factors it has alleged with respect to each count in this case, each count in this sentencing hearing. And as the attorneys know, there are 24 counts. Now, in terms of the specific objections, first, there's an objection to the slides that show the victims' names and the victims' photos, the deceased victims' names and the deceased victims' photos. That objection is overruled. The people have to prove beyond a reasonable doubt as an element of at least one of the aggravating factors that has been alleged that a particular one, that each of these victims was murdered. And so I think it's fair for them to show the name. I think it's fair for them to show a picture. The compilation of all the photographs of the deceased victims is, I think, fair, given that one of these aggravators alleges that more than two or more people were killed. So I think it's appropriate for them to show a compilation of all the photographs. So the objection under Rule 401 and 403 is overruled. These photographs and these names are relevant. They have probative value, and the probative value is not substantially outweighed by any danger of unfair prejudice. By the way, these are all photographs that the jury has seen before. This is not going to be anything new to the jury. And in this phase of the proceedings, as I said, the people have to prove beyond a reasonable doubt certain elements with respect to each, or at least one aggravator alleged with respect to each particular count. And each particular count refers to a particular victim. Actually, there are 2 counts for every deceased victim. I will sustain the objection, however, to the repetitive showing of the photograph of Veronica Mosher Sullivan. I know that there are 2 particular counts, or 2 particular, actually there's a particular aggravator that applies only to 2 counts, and that is the intentional killing of a child under 12. But the people don't need to keep showing the photograph over and over in their presentation. I think it's enough if they show it one time, and so the objection to the additional photographs of Veronica Mosher Sullivan is sustained, and I'll give the people an opportunity to modify its slides, their slides, so that they can make that change.
I just did that, Your Honor.
Okay, thank you. Slide number 38, the objection is to the use of every living soul. I do agree with Mr. Orman that this is a colloquial term, but you know, I don't know how a juror might perceive it or what a juror might infer from it. And the people don't need to say soul. They can say every living person, and it conveys the same message. So I'll sustain the objection to the word soul, but the people can put person or individual or something along those lines. So that objection is sustained. In terms of the argument related to the people not being able to prove beyond a reasonable doubt that the defendant intended to kill a child, this will be a decision for the jury to make. It's not a decision for me to make. There is certainly enough evidence here for the jury to draw reasonable inferences to prove this count. For example, there is evidence that there were children present. There is evidence that, and there's evidence from which the jury could infer that the defendant was aware of that. There's evidence from which the jury could infer that the defendant, being aware that there were children present in the theater, intentionally shot Veronica Mosher Sullivan. And actually, the people don't have to prove specifically that he intended to shoot Veronica Mosher Sullivan, but they have to prove beyond a reasonable doubt that he intended to kill a child under 12. And I think there is enough circumstantial evidence here for that the people can proceed on that aggravator. Mr. Orman mentioned that there was a baby on the same row where the defendant was seated. That's part of the evidence that he was referring to, and I agree that based on all the evidence that has been admitted, there is sufficient evidence for the jury to infer that the defendant knowing that there were children present in the theater, proceeded with his actions, and that therefore he intended to kill a child under the age of 12. There's an objection to slide number 42 because it has an arrow pointing to the picture. Initially, I was inclined to order the people to modify this exhibit, but Mr. Orman is right. He was careful not to distort the exhibit in any way, and the arrow is actually outside the photograph. And so with the arrow outside the photograph, I am comfortable that the people can proceed. There is no difference, as Mr. Orman said, between him putting his finger there or putting an arrow there or putting a stick on that and pointing to it, or using a laser point and pointing to it. I don't see a difference between any of those methods, and I think all of those methods are appropriate. By the way, the arrow in this particular case doesn't have any color. It's a white arrow, so it's a very neutral color. And so I don't have any concerns about that either. And so the objection with respect to that slide is overruled. The objection as to that slide that it will be confusing to the jury because that photograph dealt with the incendiary devices, which is not relevant to the sentencing hearing, is overruled. The photograph may have dealt with the incendiary devices because it was taken in the apartment, but certainly the photograph shows the defendant dressed up with the armor and the other equipment that he wore to the shooting. So it is also related to the shooting, and it is also relevant to these proceedings, the sentencing hearing. And under Rule 401, it is therefore admissible, and its probative value is not substantially outweighed by any of the dangers listed in Rule 403. The objection to slide 43, this is the slide that shows one of the firearms used, and it shows blood on the ground and a sandal. There is a picture of each firearm that was used in the shooting. I think the objection to this slide is that it shows blood in the sandal, and that therefore the probative value of the evidence is substantially outweighed by the danger for unfair prejudice. I disagree with the objection. Number one, this is a picture the jury has previously seen. Number two, this is a firearm that the defendant used in the shooting. And number three, this is where the firearm was found. This was the location of the firearm. It was found on the floor outside the theater. And number four, the people have to prove beyond a reasonable doubt that the defendant created a grave risk of death. For all those reasons, the picture has probative value, and I find that the probative value of the photograph is not substantially outweighed by the danger for unfair prejudice or any of the other concerns listed in Rule 403. The objections to the slides that are 66 through 91, and these are the pictures of the injuries of the victims. Ms. Brady said that this is undisputed. I disagree. I mean, the injuries may be undisputed, but the injuries go to an issue that's very much in dispute, and that is that the defendant created a grave risk of death. This is a similar argument that has been advanced before that I have rejected, where the defense will say, well, this particular point is undisputed. Well, maybe the immediate point is undisputed, but the larger point is not, and that is the point about whether the defendant created a grave risk of death to people who are not victims of the murder counts. And so given that the people have to prove that beyond a reasonable doubt, the pictures are relevant to that issue. They have probative value, and the probative value is not substantially outweighed by the danger for unfair prejudice or any of the other concerns listed in Rule 403. Again, these are all photographs that the jury has seen before. They have been admitted into evidence, and the jury has them available to them, just like the picture of the firearm that I spoke about, slide number 43. Ms. Brady said that the people don't need these photographs to prove the grave risk of death. Well, it's not up to the defense to decide how the people go about proving the aggravating factors. As long as an aggravating factor remains in dispute, the people can prove it as they see fit, as long as it is within the rules of evidence. So if the defense wants to stipulate to that particular element of the aggravating factor, then my ruling would be different. But as long as there's not a stipulation, the people are entitled to prove that the defendant created a great risk of death to victims who are not victims of the murder counts, or to people who are not victims of the murder counts. The next slide I have is 99. I went back and forth on this one. Use of the term killing zone. This is argument, and I think this is arguably appropriate for the people to use that term. But we're in a sentencing hearing, and this is in a slide. It's in writing. And so given that, I'm going to err on the side of caution and order the people to modify that term. The people don't need that term to make the point they're making. The point they're making here is that the defendant used tear gas in order to modify the environment of the theater, and that this is part of the evidence that supports the people's argument that this was unnecessarily torturous. What is relevant here is not that this was a killing zone. What is relevant is that in this theater, he deployed tear gas, and that deployment of the tear gas made this crime unnecessarily torturous. At least that's the people's argument. So I'm sustaining the objection with respect to that. I know that at the end of the trial, there was a similar objection to Mr. Brockler's use of the term kill box. But at that time, we were dealing with not the aggravator of unnecessarily torturous. We were dealing with all of the charges, all 165 charges, and the people had to prove beyond a reasonable doubt each and every element of those charges. They had to prove beyond a reasonable doubt that the defendant committed the crime, and that all the elements were met. And I thought that was fair, but I think here, given what the people are attempting to do, which is a lot more narrow, and again, I am erring on the side of caution here, so I'll sustain the objection because of that. The next one is 101. This means that the victims would experience extreme discomfort from the tear gas in addition to being shot. The objection that this is opinion by the prosecutor is overruled. This is a logical inference from the evidence. If you have someone who uses tear gas, I think there's a reasonable logical inference from the fact that the person used tear gas that the person would have known that the victims would experience discomfort from the tear gas. Frankly, I think the use of the word discomfort is a pretty mild term and an appropriate term. I'm not encouraging the people to use a different term. I'm just saying discomfort, all things considered, and given what other synonyms or other words could be used, discomfort is actually a pretty mild way to describe what would be reasonable for someone to expect would happen if he used tear gas. So the objection as to 101 is overruled. There is direct evidence that that the victims, some of the victims in this case, experienced extreme discomfort as a result of the tear gas, and I think reasonable inferences can be drawn from that that the use of tear gas would mean that the victims in the theater would experience extreme discomfort. The next one I have is 103. This one says the defendant killed his victims in a crowded movie theater, and I believe the objection is to the word his. I don't have a problem with that. This is argument that people can argue. These are the defendant's victims. The defendant has now been found guilty of all 12 murders. All 12 of these victims are his victims. So I don't have a concern with respect to the use of that word. I don't think that this is an opinion by the prosecutor. This is now fact, given the jury's guilty findings. It is not inflammatory, and I find that under Rule 403, it is appropriate and admissible because the probative value is not substantially outweighed by any of the dangers listed in Rule 403. Again, I'm mindful that this is argument. The next objection is to slide number 104. The victims were trapped by design. The argument in support of the objection is that this is based on evidence that has been excluded from this phase of the sentencing hearing because it is based on the defendant's statements to Dr. Reed. Mr. Orman responded that this is not based on the defendant's statements to Dr. Reed. This is based on other evidence and reasonable inferences that can be drawn from that evidence. I agree with Mr. Orman. I think that excluding and ignoring completely all the statements the defendant made to Dr. Reed, I think the evidence, the physical evidence, allows for reasonable logical inferences that the victims were trapped by design. The defendant went to the theater while a movie was playing in the dark and then proceeded with the shooting. I think reasonable inferences can be drawn that the victims were trapped by design without getting into any of the statements the defendant made to any psychiatrist or psychologist or mental health expert. Now, the people have to be very careful, though, to make sure that they do not reference any statements by the defendant to Dr. Reed or Dr. Metzner or anyone else, and also be careful not to, and when I say anyone else, I mean anyone else who's a mental health expert, and also to be careful not to rely in their argument on any such statements or any other evidence that has been excluded for purposes of phase one of the sentencing hearing. The next objections had to do with slides 105 through 108. Actually, I think 105 may have been the one that I just addressed about the victims being trapped by design. I'm not sure, but in any event, so the record is clear, I'll go through these one by one. I've addressed the trapped by design slide. The next one is they were unable to flee. And the argument is that this is inflammatory and not based on evidence. The people have to prove beyond a reasonable doubt an element related to especially heinous, cruel, or depraved manner, that the murder, the first-degree murder, was committed in an especially heinous, cruel, or depraved manner. At least with respect to one aggravator, the people have to prove that beyond a reasonable doubt. At the defense's specific request, I included language in the elemental instruction that says that in order to prove beyond a reasonable doubt that the defendant committed the offense of murder in the first degree in an especially heinous, cruel, or depraved manner, the prosecution must prove beyond a reasonable doubt that the defendant committed the offense in a conscienceless or pitiless manner, which was unnecessarily torturous to the victim. So, given what the people have to prove, some of these slides are appropriate. In terms of this particular slide that says they were unable to flee, the concern I have is that some of the victims were actually able to flee. So I don't think it's accurate based on the evidence. If the people want to change it to some of them were unable to flee, that's fine. But saying they were unable to flee, I don't think is completely accurate. So I'm sustaining the objection with respect to that aspect of it. Even though that wasn't really the objection, but that's still something that I consider, and I think that's improper. So that should be either modified or the slide should be deleted. And I agree with the people that the evidence does support the fact that some of the victims were unable to flee, either because they couldn't get out of their row or for whatever other reason, some of them were unable to flee. The next objections, I believe, are to slides 106 through 108, and I believe that last one was 105. So I think the one about the victims being trapped by design was 104. The one about unable to flee was 105. 106 says, knowing that every breath could be their last. I don't like this slide. This slide seems to me to be more for the effect on the jury than anything else. So I'm sustaining the objection with respect to this slide because I think it does have some inflammatory value or some inflammatory risk, and I don't think it's I don't think it does anything for the people's proof in terms of this being unnecessarily torturous. And by the way, when it says knowing that every breath could be their last, I take that to be referring to what the victims knew. The next one is in the darkness. that one doesn't bother me. It's connected to the last one, but it doesn't bother me. It's supported by the evidence, and there's nothing inflammatory about it. The next one says, and that there was nothing that they could do about it. I think this one is appropriate. It's an inference, a logical, reasonable inference that can be drawn from the evidence. I'm not saying that it's the only inference, but I think it's a logical and reasonable inference to be drawn from the evidence that as the shooting was occurring in the dark while the movie's playing, with people not knowing what was happening, with tear gas having been deployed, that the victims knew that there was nothing they could do about it. The next objection, there's an objection in here at some point to unnecessarily torturous, to the word torturous. I don't understand that objection, given that that's specifically something that I am instructing the jury about at the defense's request. So that objection is overruled. The next objection I have is what I believe is slide number 110, and I think the one that I have as torturous, the objection to the use of the word torturous, although the word torturous is used throughout the slides, I think the objection was made with respect to it on page 111 or slide 111. The objection to slide number 110 is next. The next one I'm going to address. That slide reads as follows. The defendant killed his victims so that at the moments of their death, they would not only be in fear of their own lives, but in fear for their lives, for the lives of their friends and family and loved ones. What I don't like about this slide is that it implies that this was the reason why the victims were killed in this fashion. And so I think that is objectionable, and the objection is sustained. To the extent that people want to modify it, they can modify it to say at the moment of their death, the victims were not only in fear of their own lives, but in fear for the lives of their friends and family and loved ones. I think that's a reasonable inference, not only a reasonable inference from the evidence, but actually directly supported by the evidence. Next is slide number 112, which says the defendant killed his victims in a manner so that the victims would die surrounded by screaming and pain and anguish. Same ruling, same concern. It implies that this is why this was done in this fashion. And I don't think that's a reasonable inference from the evidence. Again, if the people want to say that the victims died surrounded by screaming and pain and anguish, I think that's a reasonable inference that can be drawn from the evidence, and frankly, that is directly supported by the evidence. But as drafted, I find that it is objectionable. So the objection to the slide as drafted is sustained. The next ones are slides 117 to 120, which have to do with the aggravating factor of while lying in wait or from ambush. And again, this is something that people have to prove beyond a reasonable doubt. So I don't see any problems with any of these slides. The slides are as follows. The victims were unaware of any danger, watching, and then the next point or the next part would say watching a movie. The next part would say helpless. The next part would say the defendant was in a place of concealment. All of that is directly supported by the evidence in this case. So the objections as to all of those slides are overruled. The last one I have is slide number 123, which reads, the victims had no way to know that danger lurked right outside. The people are willing to change lurked to stood, and that would be my order. So that word should be changed. That takes care of all the objections and the responses to the objections. Did the people, did those rulings, were those rulings clear, Mr. Orman?
They are, Your Honor. I've made the changes.
Great, thank you. All right, do you need any time then before I bring the jury in?
I do not, Your Honor.
All right, is the defense ready for the jury?
Yes.
Okay, let's bring the jury in, please. Please be seated, everyone. The record should reflect that the jury is now back in the courtroom. Good morning, folks. How's everyone doing? Good. I trust that you had a restful few days. I know that the plan was that we would take some days off so that the attorneys and I could work on some things, and then we would be ready to go first thing this morning. And unfortunately, we weren't able to start right away this morning. I want to make sure that you don't hold that against either party. I want to remind you about that. It's not either side's fault. Blame it on me if you must. Blame it on someone. Do not take it out on either side, okay? But I do appreciate your patience. That means a lot to me. You folks have been extremely patient throughout, and I appreciate that. What I'm going to do now is ask my staff to distribute some instructions. So if you would do that, please. These are introductory instructions, and we're going to give each of you a copy so that you can follow along as I read them here in the courtroom. We are going to retrieve these instructions from you once I'm done reading them, and then we will proceed with the sentencing hearing. All right, does everybody have one? Everybody's saying yes and not in their head yes. Okay, let's start sentencing hearing phase 1, introductory instruction number 1. And please follow along as I read this to you. Members of the jury, now that the trial has been completed, we are starting the sentencing hearing. It is your duty to determine the punishment to be imposed on the defendant for the commission of the crimes of murder in the first degree. You will be solely responsible for determining such punishment. Based upon your earlier verdicts, the defendant has been found guilty of 24 counts of murder in the first degree. As you know, there are 2 guilty verdicts for murder in the first degree with respect to each deceased victim because the prosecution pursued 2 theories of liability as to each deceased victim: murder in the first degree after deliberation and murder in the first degree extreme indifference. The 2 guilty verdicts for each deceased victim will eventually merge into a single conviction for murder in the first degree, and based solely on the jury's sentencing verdicts, the defendant will receive a single sentence for that conviction. Accordingly, the defendant will stand convicted of 12 murders in the first degree, and the jury's sentencing verdicts alone will determine the sentences for those crimes. You must make 24 separate determinations, one for each count of murder in the first degree, in any phase we go through in this sentencing hearing. Only the 24 counts of murder in the first degree are subject to the sentencing hearing. It is not your responsibility to determine the punishment for the other 141 offenses of which the defendant was found guilty. The law requires that I, as the judge, impose the sentences for those offenses. I will sentence the defendant on those offenses at a later date. In Colorado, the crime of murder in the first degree may be punished by either imprisonment for life without the possibility of parole or death by lethal injection. Therefore, there will be 2 sentencing choices in this sentencing hearing with respect to each count: the penalty of life imprisonment without the possibility of parole or the penalty of death. Under Colorado law, a sentence of life imprisonment without the possibility of parole means just that. The person receiving the sentence must spend the rest of his natural life in prison. A defendant in Colorado who is sentenced to life imprisonment without the possibility of parole cannot ever apply for parole or ever be released on parole. A death sentence is never mandatory or required. The law never requires a death sentence. The fact that the defendant has been found guilty of murder in the first degree does not mean that a death sentence is required or appropriate. The court reminds you that no defendant may ever be sentenced to death based solely on a conviction for murder in the first degree. The sentencing hearing may consist of up to 3 phases. The purpose of the sentencing hearing is to determine the appropriate sentence to be imposed upon the defendant for the crimes of murder in the first degree. You must consider the evidence presented and the arguments of the attorneys with an open mind. I may give you instructions at the beginning of any phase of the sentencing hearing that we may go through. Additionally, I will give you detailed instructions at the close of the evidence and prior to your deliberations at the end of any phase of the sentencing hearing we may go through. Colorado law requires that you carefully follow the instructions I give you as you make any decision during the sentencing hearing. I will now provide an overview as to how this sentencing hearing will be conducted. Please keep in mind that these are just introductory instructions. You will be given more detailed instructions later on during the hearing. Further, you should not infer from these introductory instructions that there will be a phase 2 or a phase 3 in this sentencing hearing. I'm giving you these introductory remarks about all three possible phases, even though we may never get to phase 2 or phase 3, because it is important that you have a basic understanding of these phases before we proceed with the sentencing hearing. Phase 1. In phase 1, the prosecution has the burden of proof with respect to each count of murder in the first degree. As to each count, the prosecution is required to prove beyond a reasonable doubt the existence of at least one of the aggravating factors it has alleged in this case. Therefore, you must make 24 separate determinations in phase 1 of the sentencing hearing. As to each of the 24 counts of murder in the first degree, you must decide whether the prosecution has proven beyond a reasonable doubt the existence of at least one alleged aggravating factor. Before finding the existence of an alleged aggravating factor with respect to any count, the jury must unanimously agree that the prosecution has proven beyond a reasonable doubt that alleged aggravating factor. To prove an alleged aggravating factor beyond a reasonable doubt, the prosecution must prove beyond a reasonable doubt each of the elements of the aggravating factor. There is a statute in Colorado that lists possible aggravating factors. Consequently, aggravating factors are sometimes referred to as statutory aggravating factors. An aggravating factor is a fact or circumstance that increases the severity or seriousness of the defendant's conduct. In this case, the prosecution has alleged the following 5 statutory aggravating factors. Number 1, the prosecution alleges that the defendant unlawfully and intentionally, knowingly or with universal malice, manifesting extreme indifference to the value of human life generally, killed 2 or more persons during the commission of the same criminal episode. Number 2, the prosecution alleges that the defendant intentionally killed a child who had not yet attained 12 years of age. Number 3, the prosecution alleges that in the commission of the offense of murder in the first degree, the defendant knowingly created a grave risk of death to another person in addition to the victim of the offense. Number 4, the prosecution alleges that the defendant committed the offense of murder in the first degree in an especially heinous, cruel, or depraved manner. And number 5, the prosecution alleges that the defendant committed the offense of murder in the first degree while lying in wait or from ambush. At the end of phase 1, the jury will deliberate. If the jury does not unanimously find that the prosecution has proven beyond a reasonable doubt the existence of at least one of these aggravating factors with respect to a count of murder in the first degree, the jury must render a sentencing verdict of life imprisonment without the possibility of parole on that count. On the other hand, if the jury unanimously finds that the prosecution has proven beyond a reasonable doubt at least one of these aggravating factors with respect to a count of murder in the first degree, the jury must render a verdict that reflects that finding, and the sentencing hearing will continue to phase 2 on that count. Phase 2. In Phase 2, if there is a Phase 2, the defendant may, but is not required to, present mitigation, although the jury must consider all evidence of mitigation regardless of who presents it. The law requires the jury to give full consideration and effect to all mitigation presented. A mitigating factor is a fact or circumstance which does not constitute justification or excuse for the offenses in question, but which in fairness or mercy may be considered as extenuating or reducing the degree of the defendant's moral culpability. Thus, mitigation refers to a fact or circumstance that might cause a juror to vote for a life sentence. There is a statute in Colorado that lists possible mitigating factors. Therefore, they are sometimes referred to as statutory mitigating factors. One of the mitigating factors listed in the statute is any evidence which bears on the question of mitigation. In other words, mitigation is any evidence that might cause a juror to vote for a life sentence. If the defendant presents mitigation evidence, the prosecution will have the opportunity to rebut that evidence. At the end of Phase 2, the parties will have an opportunity to make closing arguments, with the defense going first and the prosecution going next. The jury will then deliberate. Each juror must individually determine whether one or more mitigating factors exist. The jury need not unanimously agree that mitigating factors exist or that the same mitigating factors exist. Each juror must then weigh the mitigating factors that he or she has determined exist against the aggravating factors proven by the prosecution beyond a reasonable doubt in Phase 1. This process is not a mere counting process. Your decision should not be mechanical or mathematical. Rather, the weighing process requires a critical evaluation of any mitigating factors and the aggravating factors proven. Each juror must individually decide whether he or she is convinced beyond a reasonable doubt that any mitigating factors do not outweigh the proven aggravating factors. Neither party has the burden to prove anything in Phase 2. However, as to each count of murder in the first degree, the sentencing hearing will only continue to Phase 3 if the jury unanimously finds beyond a reasonable doubt that the mitigating factors do not outweigh the aggravating factors. If, with respect to a count, the jury unanimously finds beyond a reasonable doubt that the mitigating factors do not outweigh the aggravating factors, it must return a verdict that reflects that finding, and the sentencing hearing will continue to Phase 3 on that count. Otherwise, the sentencing hearing as to that count ends, and the defendant will be sentenced on that count to life imprisonment without the possibility of parole. In reaching your decisions during Phase 2, you must not be influenced by prejudice or bias of any sort against the defendant. You must treat the defendant as a uniquely individual human being, and you must not consider any public opinion or community sentiment for or against him. A juror must use his or her individual reasoned moral judgment during this phase of the sentencing hearing. Further, each juror may consider mercy for the defendant during Phase 2 of the sentencing hearing. Your exercise of moral judgment and mercy must be based upon evidence and or information that was 1. Presented during the trial and that I tell you may be considered, and or 2. Presented during the sentencing hearing. The law requires that your decisions not be the result of mere passion, bias, prejudice, conjecture, or any other irrational or arbitrary emotional response. Phase 3. In Phase 3, if there is a Phase 3, both the prosecution and the defense may present additional evidence and information. At the end of Phase 3, the parties will have an opportunity to make closing arguments, with the prosecution going first and the defense going next. Each side may also have an opportunity to make a rebuttal closing argument, with the prosecution going first and the defense going last. The jury will then deliberate in order to decide the appropriate sentence on each count of murder in the first degree, life imprisonment without the possibility of parole, or death. During the deliberations at the end of Phase 3, each juror must individually determine the appropriate sentence on each count. Neither party has the burden to prove anything in Phase 3. However, the jury may only return a verdict of death on account of murder in the first degree if it is unanimously convinced beyond a reasonable doubt that death is the appropriate punishment. If the jury is not unanimously convinced beyond a reasonable doubt that death is the appropriate punishment on a particular count, it must either 1. Return a unanimous verdict of life imprisonment without the possibility of parole, or 2. Notify the court that it is unable to reach a unanimous verdict. If the jury is unable to reach a unanimous verdict on a count, the defendant will be sentenced to life imprisonment without the possibility of parole on that count. In reaching a verdict in Phase 3, you must not be influenced by prejudice or bias of any sort against the defendant. You must treat the defendant as a uniquely individual human being, and you must not consider any public opinion or community sentiment for or against him. A juror must use his or her individual reasoned moral judgment during this phase of the sentencing proceedings. Each juror may consider mercy for the defendant during Phase 3. Your exercise of moral judgment and mercy must be based upon evidence and or information that was 1. Presented during the trial and that I tell you may be considered, and or 2. Presented during the sentencing hearing. The law requires that your decisions not be the result of mere passion, bias, prejudice, conjecture, or any other irrational or arbitrary emotional response. With regard to each count, each juror must apply his or her reasoned moral judgment in deciding the appropriate sentence in light of the totality of the circumstances present. As to each count, each juror must ultimately make a reasoned moral assessment of whether death or life imprisonment without the possibility of parole is the appropriate punishment for the defendant on that count. The jury's sentencing verdict on each count must be based on a profoundly moral evaluation of the defendant's character and crime. Sentencing hearing Phase 1, Introductory Instruction Number 2. In a sentencing hearing, the parties may rely on the evidence introduced during the trial that the court instructs you may be considered. Therefore, the prosecution may opt to proceed in Phase 1 solely by presenting argument. Although the defendant does not have a burden of proof in Phase 1 or at any other time in a sentencing hearing, he may present evidence and or his attorneys may present argument. Sentencing hearing Phase 1 Introductory Instruction Number 3. To the extent that I tell you that you may only consider certain evidence introduced during the trial for a limited purpose, you may only consider such evidence for the limited purpose that I tell you it may be considered. Similarly, to the extent that I tell you that you may only consider certain evidence introduced during the sentencing hearing for a limited purpose, you may only consider such evidence for the limited purpose that I tell you it may be considered. Sentencing hearing Phase 1 Introductory Instruction Number 4. Reasonable doubt means a doubt based upon reason and common sense, which arises from a fair and rational consideration of all of the evidence or the lack of evidence. It is a doubt which is not a vague, speculative, or imaginary doubt, but such a doubt as would cause reasonable people to hesitate to act in matters of importance to themselves. With respect to each count, the prosecution has the burden to establish that at least one of the 5 aggravating factors alleged has been proven beyond a reasonable doubt. The defendant has no burden of proof in Phase 1 or at any point in the sentencing hearing. All right, that concludes the reading of the sentencing hearing Phase 1 Introductory Instructions. So I'm going to have my staff retrieve all of those copies from you at this time. And the record should reflect that Ms. Gerlings is doing just that right now. the record should reflect that Ms. Gerlings has now collected all of the copies of my introductory remarks to this sentencing hearing. All right, at this time, do the people have any evidence to present in phase one?
No additional evidence, Your Honor.
Does the defense have any evidence it wishes to present in this phase one?
No, sir.
All right. Members of the jury, since the parties have rested and the evidence has been completed in this phase one, the next step in the proceedings is for me to give you the final jury instructions. And just like we did with the final jury instructions at the end of the trial, you'll get to keep your copy of these instructions, and those of you who deliberate will get to have them with you during deliberations. And so I'm going to have my staff now distribute to each of you a copy of the final phase one jury instructions. And once you each have received a copy, I am going to read them verbatim here in the courtroom and ask you to follow along as I read them to you. After I finish reading the instructions to you, the final instructions to you, the attorneys will have an opportunity to make their closing arguments, and then the jury will deliberate, okay? All right, does everyone have a copy? Yes, everyone has a copy. Okay, let's start. Jury instructions, phase one of sentencing hearing, instruction numbers 1 through 18, given by the court this 22nd day of July of 2015. Sentencing hearing, phase one, instruction number 1. Members of the jury, phase one of the sentencing hearing has been completed. In a moment, I will read to you jury instructions that contain the rules of law you must apply to reach your phase one sentencing verdicts. You will have copies of what I read to take with you to the jury room. But first, I want to mention a few things you need to keep in mind when you are discussing this case in the jury room. In these instructions, I refer to the first part of the proceedings as the trial, and to the present part of the proceedings as the sentencing hearing. Until you have returned your phase one sentencing verdicts, you must follow all of the following admonishments. You must reach your phase one sentencing verdicts based only on the evidence presented in the courtroom that I tell you may be considered in the instructions of law provided by the court. This includes most, but not all, of the evidence presented during the trial, as I will explain later in these instructions. Do not communicate about the case with anyone else in any way, including in person, by telephone, cell phone, smartphone, iPhone, BlackBerry, computer, the internet, or any internet service. This means that you must not email, text, instant message, tweet, blog, or post information about this case or about your experience as a juror in this case on any website, listserv, chat room, blog, or website such as Facebook, MySpace, LinkedIn, YouTube, or Twitter. You must not communicate in any way with anyone else about this case or this kind of case. This includes your family, members, and friends. You must not read, review, or accept any communications in any form from anyone regarding this case or a case like this one. All you can tell family members, friends, acquaintances, and strangers is that you're on a jury in Arapahoe County that is anticipated to be completed at the latest by the end of August. If you notice that people are discussing the case, remove yourself from that location immediately. Do not attempt to gather any information on your own about this case. You must not read or conduct any research about this case or this kind of case using any source, including dictionaries, reference materials, the internet, or any other electronic means. Many of us routinely use the internet to research topics of interest, but you may not do that in relation to this case. You may not use Google, Bing, Yahoo, or any other type of internet search engine to learn about any person, place, or thing that is involved in this case. This includes the defendant, the attorneys, the witnesses, your fellow jurors, court personnel, and me. This applies whether you're here at home or anywhere else. Do not read about this case in the newspaper or on the internet. Do not listen to any radio broadcast about the trial, and do not watch any television news reports regarding the trial. Do not attempt to visit any places mentioned in this case. Do not in any way, in any other way, try to learn about this case or this kind of case outside the courtroom. Do not talk to the witnesses, parties, and attorneys about anything. Do not talk to any members of the media about anything. Do not have any contact through any means, including in person, by telephone, text, or email, with any jurors who have been discharged. You also should not have any contact through any means, including in person, by telephone, text, or email, with any of the alternate jurors. Make sure you wear your juror badge whenever you're on the courthouse grounds and that your juror badge is visible to those around you. If you have a cell phone or other electronic device, you must temporarily surrender it to my staff. You're not allowed to have a cell phone or other electronic device in the jury room during your deliberations. You will get your electronic devices at the end of the day before you go home. Lastly, although you may start deliberating when I tell you that you may do so, you may discuss this case only when you are all present and only when you are in the jury room. No juror should attempt to discuss this case with another juror or other jurors except when all the jurors are present in the jury room. All deliberations must occur in the jury room when all 12 jurors are present. It is my job to decide what rules of law apply to the case. While the attorneys may comment on some of these rules, you must follow the instructions I give you. Even if you disagree with or do not understand the reasons for some of the rules of law, you must follow them. No single instruction describes all the law which must be applied. The instructions must be considered together as a whole. You have received all of the evidence that you may properly consider in reaching your Phase 1 sentencing verdicts. Your Phase 1 sentencing verdicts must be made by applying the rules of law that I give you to the evidence presented during the trial that I tell you may be considered. Remember that you must not be influenced by sympathy, bias, passion, prejudice, or any other arbitrary factor in reaching your Phase 1 sentencing verdicts. At times during the proceedings, the attorneys have made objections. Do not draw any conclusions from the objections or from my rulings on the objections. These only related to legal questions that I had to decide and should not influence your thinking. If I told you not to consider a particular statement that was made during the proceedings, you must not consider it in your deliberations. Similarly, if during the trial I sustain an objection to a question after a witness had already provided an answer or partial answer, you must not consider any part of that answer in your deliberations. I asked questions of witnesses during the trial. That did not mean that I had any opinion about the facts in the case. Remarks and rulings I have made during the trial and the sentencing hearing should not be understood by you as suggesting any opinion or feeling on my part as to what has or has not been proven in this case. Further, remarks and rulings I have made during the trial and the sentencing hearing should not be understood by you as suggesting any opinion or feeling on my part as to what Phase 1 sentencing verdicts you should reach. I remind you that I am neutral in these proceedings. Sentencing hearing Phase 1 instruction number 2. You are instructed that in determining whether the prosecution has met its burden of proof in Phase 1 of the sentencing hearing, you are to give separate and individual consideration to each alleged aggravating factor with respect to each count of murder in the first degree. In this phase of the sentencing hearing, the prosecution has the burden of proving beyond a reasonable doubt at least one alleged aggravating factor with respect to each count. The evidence and the law applicable to each alleged aggravating factor should be considered separately and influenced by your decisions as to any other alleged aggravating factors. Likewise, the evidence and the law applicable to each count should be considered separately and influenced by your decisions as to any other count. Regarding each count, the fact that you may or may not find that the prosecution has proven beyond a reasonable doubt the existence of an alleged aggravating factor should not control your decision as to whether the prosecution has proven beyond a reasonable doubt the existence of any other alleged aggravating factor with respect to that count or any alleged aggravating factor with respect to any other count. Based upon your earlier verdicts, the defendant has been found guilty of 24 counts of murder in the first degree. As you know, there are two guilty verdicts for murder in the first degree with respect to each deceased victim because the prosecution pursued two theories of liability as to each deceased victim: murder in the first degree after deliberation and murder in the first degree extreme indifference. The two guilty verdicts for each deceased victim will eventually merge into a single conviction for murder in the first degree, and based solely on the jury's sentencing verdicts, the defendant will receive a single sentence for that conviction. Accordingly, the defendant will stand convicted of 12 murders in the first degree, and the jury's sentencing verdicts alone will determine the sentences for those crimes. You must make 24 separate determinations in phase 1 of the sentencing hearing. As to each of the 24 counts of murder in the first degree, you must decide whether the prosecution has proven beyond a reasonable doubt the existence of at least one alleged aggravating factor. Before finding the existence of an alleged aggravating factor with respect to any count, the jury must unanimously agree that the prosecution has proven beyond a reasonable doubt that alleged aggravating factor. Sentencing hearing phase 1 instruction number 3. With respect to each count of murder in the first degree, you shall presume that an aggravating factor alleged by the prosecution does not exist unless you unanimously find that the prosecution has proven beyond a reasonable doubt the existence of that alleged aggravating factor. The burden of proof in phase 1 of the sentencing hearing is upon the prosecution to prove to your satisfaction beyond a reasonable doubt the existence of at least one of the aggravating factors alleged with respect to each count of murder in the first degree. To prove beyond a reasonable doubt the existence of an alleged aggravating factor, the prosecution must prove to your satisfaction beyond a reasonable doubt all the elements of the alleged aggravating factor. The defendant has no burden of proof. Please keep in mind that in reaching your guilty verdicts on the 24 counts of murder in the first degree, you were not asked to determine or even consider whether the prosecution had proven beyond a reasonable doubt the existence of the aggravating factors alleged for purposes of the sentencing hearing. You are now being called to make an independent determination regarding whether the prosecution has proven beyond a reasonable doubt the existence of at least one alleged aggravating factor with respect to each of the 24 counts of murder in the first degree. If the jury does not unanimously find that the prosecution has proven beyond a reasonable doubt the existence of at least one alleged aggravating factor with respect to a count of murder in the first degree, the sentencing hearing will end as to that count, and the jury will render a sentencing verdict of life imprisonment without the possibility of parole on that count. If the jury unanimously finds that the prosecution has proven beyond a reasonable doubt the existence of at least one alleged aggravating factor with respect to a count of murder in the first degree, the sentencing hearing will continue on that count to phase 2. The jury cannot find that an alleged aggravating factor has been proven with respect to a count unless each juror agrees that each element of the alleged aggravating factor has been proven by the prosecution beyond a reasonable doubt with respect to that count. Sentencing hearing phase 1, instruction number 4. Reasonable doubt means a doubt based upon reason and common sense which arises from a fair and rational consideration of all of the evidence or the lack of evidence in the case. It is a doubt which is not a vague, speculative, or imaginary doubt, but such a doubt as would cause reasonable people to hesitate to act in matters of importance to themselves. Sentencing hearing phase 1, instruction number 5. You are instructed that the fact that the prosecution seeks the death penalty in this case is entitled to no weight whatsoever in your decisions in phase 1 of the sentencing hearing. No juror should allow himself or herself to be influenced or prejudiced against the defendant because of the fact that the prosecution seeks the death penalty. Sentencing hearing phase 1, instruction number 6. The fact that the prosecution asserts that aggravating factors exist in this case is not evidence. You should not consider those assertions as any proof or evidence that the alleged aggravating factors exist. Sentencing hearing phase 1 instruction number 7. In reaching your phase 1 sentencing verdicts, you may consider any evidence that was presented during the trial with one exception. You may not consider any evidence that was admitted during the trial solely for your consideration of the issues raised by the defendant's plea of not guilty by reason of insanity. Additionally, the court reminds you that during the trial it admitted other evidence for a limited purpose. You may consider such evidence in making your decisions in phase 1 of the sentencing hearing only for the limited purpose I told you about when it was admitted. Sentencing hearing phase 1 instruction number 8. Regarding the evidence admitted during the trial that you may consider in reaching your phase 1 sentencing verdicts, the court reminds you that a fact may be proven by either direct or circumstantial evidence. Under the law, both are acceptable ways to prove something. Neither is necessarily more reliable than the other. Direct evidence is based on first-hand observation of the fact in question. For example, a witness's testimony that he or she looked out a window and saw snow falling might be offered as direct evidence that it had snowed. Circumstantial evidence is indirect. It is based on observations of related facts that may lead you to reach a conclusion about the fact in question. For example, a witness's testimony that he or she looked out a window and saw snow covering the ground might be offered as circumstantial evidence that it had snowed. Sentencing hearing phase 1 instruction number 9. Regarding the evidence admitted during the trial that you may consider in reaching your phase 1 sentencing verdicts, the court reminds you that the number of witnesses testifying for or against a certain fact during the trial does not, by itself, prove or disprove that fact. Sentencing hearing phase 1 instruction number 10. Regarding the evidence admitted during the trial that you may consider in reaching your phase 1 sentencing verdicts, the court reminds you that you are the sole judges of the credibility of each witness who testified during the trial and the weight to be given to each witness's testimony. You should carefully consider all of the testimony given and the circumstances under which each witness has testified. For each witness, consider that person's knowledge, motive, state of mind, demeanor, and manner while testifying. Consider the witness's ability to observe, the strength of that person's memory, and how that person obtained his or her knowledge. Consider any relationship that the witness may have to either side of the case and how each witness might be affected by the verdict. Consider how the testimony of the witness is supported or contradicted by other evidence in the case. You should consider all facts and circumstances shown by the evidence when you evaluate each witness's testimony. You may believe all of the testimony of a witness, part of it, or none of it. Sentencing hearing phase 1 instruction number 11. Regarding the evidence admitted during the trial that you may consider in reaching your phase 1 sentencing verdicts, which does not include evidence admitted solely for your consideration of the issues raised by the defendant's plea of not guilty by reason of insanity, the court reminds you that you are not bound by the testimony of witnesses who testified as experts during the trial. The credibility of an expert's testimony is to be considered as that of any other witness. You may believe all of an expert witness's testimony, part of it or none of it. The weight that you give the testimony is entirely your decision. Sentencing hearing phase 1 instruction number 12. Every defendant has a constitutional right not to testify. The decision not to testify cannot be used as a negative inference and cannot prejudice the defendant. It is not evidence, does not prove anything, and must not be considered for any purpose. Although the defendant has been found guilty of murder in the first degree, he retains his constitutional right not to testify during the sentencing hearing. The defendant exercised his constitutional right not to testify during the trial and phase 1 of the sentencing hearing. You shall not draw any negative inference from the defendant's exercise of his constitutional right not to testify. The exercise of this constitutional right cannot prejudice the defendant in any way. The defendant's exercise of his constitutional right not to testify cannot be used as a reason to find that the prosecution has proven any alleged aggravating factor. Sentencing hearing, phase 1, instruction number 13. At this phase of the sentencing hearing, for each of the 24 counts of murder in the first degree of which the defendant was found guilty, you must determine whether the prosecution has proven beyond a reasonable doubt the existence of at least one of the aggravating factors it has alleged. On this particular issue, the prosecution has the burden of proof. The defendant has no burden of proof. In order to meet its burden of proof, the prosecution must prove beyond a reasonable doubt all the elements of at least one alleged aggravating factor with respect to each count of murder in the first degree. The elements of alleged aggravating factor number 1, 2 or more people, are A, that the defendant, B, unlawfully, C, intentionally, knowingly, or with universal malice manifesting extreme indifference to the value of human life generally, D, killed 2 or more persons, E, during the commission of the same criminal episode. The elements of alleged aggravating factor number 2, intentionally killed a child under 12 years of age, are A, that the defendant, B, intentionally, C, killed a child who had not yet attained 12 years of age. Note, aggravating factor number 2 is only alleged with respect to counts 9 and 21. The elements of alleged aggravating factor number 3 created a great risk of death to another person in addition to the 12 victims of the crimes of murder in the first degree are A, that the defendant, B, in the commission of the offense of murder in the first degree, C, knowingly, D, created a great risk of death to another person in addition to the 12 victims of the crimes of murder in the first degree. The elements of alleged aggravating factor number 4, especially heinous, cruel, or depraved manner, are A, that the defendant, B, committed the offense of murder in the first degree, C, in an especially heinous, cruel, or depraved manner. In order to prove beyond a reasonable doubt that the defendant committed the offense of murder in the first degree, in an especially heinous, cruel, or depraved manner, as alleged in this aggravating factor, the prosecution must prove beyond a reasonable doubt that the defendant committed the offense in a conscienceless or pitiless manner, which was unnecessarily torturous to the victim. The elements of alleged aggravating factor number 5, lying in wait or from ambush, are A, that the defendant committed the offense of murder in the first degree, that was B, and C, while lying in wait or from ambush. After considering all the evidence, if you decide that the prosecution has proven beyond a reasonable doubt each of the elements of an alleged aggravating factor with respect to a count of murder in the first degree, you should find that the alleged aggravating factor proven exists with respect to that count. After considering all the evidence, if you decide that the prosecution has failed to prove beyond a reasonable doubt any one or more of the elements of an alleged aggravating factor with respect to a count of murder in the first degree, you should find that the alleged aggravating factor that was not proven does not exist with respect to that count. Sentencing hearing, phase 1, instruction number 14. Certain words and phrases used in the aggravating factors alleged have particular meanings. Accordingly, you are to use the following definitions where these words and phrases appear in these instructions and in the verdict forms. A person acts intentionally or with intent When his conscious objective is to cause the specific result prescribed by the statute defining the offense, it is immaterial whether or not the result actually occurred. A person acts knowingly or willfully with respect to conduct or to a circumstance described by a statute defining an offense when he is aware that his conduct is of such nature or that such a circumstance exists. A person acts knowingly or willfully with respect to a result of his conduct when he is aware that his conduct is practically certain to cause the result. Sentencing hearing phase 1, instruction number 15. You were permitted to submit written questions to witnesses during the trial. If a particular question was not asked, do not guess why the question was not asked or what the answer might have been. My decision not to ask a question submitted by a juror was not a reflection on the person asking it, and you should not attach any significance to the failure to ask a question. By making legal rulings on the admissibility of questions, I did not intend to suggest or express my opinion about the question. My decision whether or not to allow a question was based on the applicable rules of evidence and other rules of law, and not on the facts of this particular case. It is my responsibility to assure that all parties receive a fair trial according to the law and the rules of evidence. The fact that certain questions were not asked must not affect your consideration of the evidence in any way. Do not give greater weight to questions or answers to questions that were submitted by yourself or your fellow jurors. In making your decisions, you must consider all of the evidence that has been presented. You should modify that by adding that I tell you may be considered. So that sentence should read, in making your decisions, you must consider all of the evidence that has been presented that I tell you may be considered. Does everyone get that? Anyone need a pen or a pencil to make that change on your copy? For the record, I made the change by hand on the original. I have the original set here, and this set will go back to the jury room during deliberations. Did everyone make that change? I'll repeat it one more time. The last sentence should read as follows. In making your decisions, you must consider all of the evidence that has been presented that I tell you may be considered. So we're adding at the end of that sentence that I tell you may be considered. And the reason I'm doing that is that I gave you an instruction earlier that says that there is certain evidence that was admitted during the trial that you cannot consider during your deliberations after phase 1. Does everyone get that? Everyone's saying yes and nodding their head yes. Wonderful. All right. Is everybody finished making that change? Okay, now everyone is. Great. Sentencing hearing phase 1, instruction number 16. You have been allowed to take notes. Whether or not you took notes, you should rely on your memory as much as possible. The notes you took are to refresh your own memory. You should not give additional weight to the comments of any juror based upon the quantity or quality of his or her note-taking. Sentencing hearing phase 1, instruction number 17. Once you begin your deliberations, if you have a question, your foreperson should write it on a piece of paper, sign it, and give it to one of the bailiffs who will bring it to me. The court will then determine the appropriate way to answer the question. However, there may be some questions that, under the law, the court is not permitted to answer. Please do not speculate about what the answer to your question might have been or why the court is not able to answer a particular question. Finally, please be sure to keep the original question and response. Do not destroy them, as they are part of the official record in this case and must be returned to me when you return the instructions and verdict forms at the end of the case. Sentencing hearing phase 1, instruction number 18. Following the attorney's arguments at the end of phase 1 of the sentencing hearing, the bailiffs will escort you to the jury room so that you may deliberate. It is your duty as jurors to consult with one another and to deliberate. However, each of you must individually decide the issues for yourself after discussion and consideration of the evidence presented during the trial, which I tell you may be considered. Your foreperson will preside over your deliberations and shall sign the part of a sentencing hearing phase 1 verdict form according to the rules that I am about to explain. Each sentencing hearing phase 1 verdict must be reflected in Part A of the verdict form and must represent the considered judgment of each juror. Similarly, if you decide you should complete Part B of the verdict form with respect to a count, your response or responses to that part of the verdict form must represent the considered judgment of each juror and must be unanimous. All of you must agree to all parts of each verdict form. You will be given 24 sentencing hearing phase 1 verdict forms, one for each count of murder in the first degree. Each sentencing hearing phase 1 verdict form shall be completed in the manner that reflects your decision or decisions and shall be signed by the foreperson as indicated. There are two parts to each verdict form, Part A and Part B. If the jury unanimously finds that the prosecution has proven beyond a reasonable doubt the existence of at least one alleged aggravating factor with respect to a count of murder in the first degree, the jury should have the foreperson sign only on the designated line in Section 1 of Part A of the verdict form for that count. In that event, the sentencing hearing on that count will continue to phase 2. If the jury does not unanimously find that the prosecution has proven beyond a reasonable doubt the existence of at least one alleged aggravating factor with respect to a count of murder in the first degree, the jury should have the foreperson sign only on the designated line in Section 2 of Part A of the verdict form for that count. In that event, the jury will render a sentencing verdict of life imprisonment without the possibility of parole on that count. Only one sentencing verdict shall be returned signed in Part A of each sentencing hearing phase 1 verdict form. If the jury does not unanimously find the prosecution has proven beyond a reasonable doubt the existence of at least one alleged aggravating factor with respect to a count of murder in the first degree, the jury should disregard Part B of the verdict form for that count. If, however, the jury unanimously finds that the prosecution has proven beyond a reasonable doubt the existence of at least one alleged aggravating factor with respect to a count of murder in the first degree, the jury must complete Part B of the verdict form for that count by having the foreperson mark with an X in ink the bracket or brackets next to the aggravating factor or factors that the jury unanimously finds the prosecution has proven beyond a reasonable doubt. The sentencing hearing phase 1 verdict forms and these instructions shall remain in the possession of your foreperson until I call for them in open court. Upon reaching your sentencing verdicts, you will inform the bailiffs, who in turn will notify me, and you will remain in your jury room until called into the courtroom. I will now read two sample sentencing hearing phase 1 verdict forms. You must not draw any inferences based on the verdict forms I have selected to read to you. And everyone has a copy of the sample verdict forms. Is that correct? Great. Okay, let's go through those at this time then. And again, these are just two sample verdict forms that I randomly chose. Sentencing hearing phase 1 verdict form. Count 1, murder in the first degree after deliberation, Jonathan Blanc. Part A. 1. We, the jury, do unanimously find that the prosecution, there's a typo there, so please ignore that. That should read the prosecution, has proven beyond a reasonable doubt the existence of at least one of the alleged aggravating factors with respect to this count of murder in the first degree. And by the way, it looks like the original verdict forms do not contain that typo, so we don't have to worry about it. And then there is a spacer for the foreperson to sign in case that's the jury's sentencing verdict. 2, we, the jury, do not unanimously find that the prosecution has proven beyond a reasonable doubt the existence of at least one of the alleged aggravating factors with respect to this count of murder in the first degree. Therefore, we, the jury, render a sentencing verdict of life imprisonment without the possibility of parole on this count. And there's a space there for the foreperson to sign in case that's the jury's sentencing verdict. The single asterisk reads as follows. If the jury unanimously finds that the prosecution has proven beyond a reasonable doubt the existence of at least one alleged aggravating factor with respect to this count, the foreperson should sign only on the designated line in section 1 above. The jury must then complete Part B of this verdict form. The double asterisk reads as follows. If the jury does not unanimously find that the prosecution has proven beyond a reasonable doubt the existence of at least one alleged aggravating factor with respect to this count, the foreperson should sign only on the designated line in section 2 above. The jury should then disregard Part B of this verdict form. Part B. If the jury does not unanimously find that the prosecution has proven beyond a reasonable doubt the existence of at least one alleged aggravating factor with respect to this count, the jury should disregard this Part B. If, however, the jury does unanimously find that the prosecution has proven beyond a reasonable doubt the existence of at least one alleged aggravating factor with respect to this count, the jury must complete this Part B by having the foreperson mark with an X in ink the bracket or brackets next to the aggravating factor or factors that the jury unanimously finds the prosecution has proven beyond a reasonable doubt. The first bracket reads as follows. Alleged aggravating factor number 1, 2 or more persons. The defendant unlawfully and intentionally, knowingly, or with universal malice, manifesting extreme indifference to the value of human life generally, killed 2 or more persons during the commission of the same criminal episode. Note, alleged aggravating factor number 2, intentionally killed a child under 12 years of age, does not apply to this count. The next bracket reads as follows. Alleged aggravating factor number 3, created a grave risk of death to another person in addition to the 12 victims of the crime of murder in the first degree. In the commission of the offense of murder in the first degree, the defendant knowingly created a grave risk of death to another person in addition to the 12 victims of the crimes of murder in the first degree. The next bracket reads as follows. Alleged aggravating factor number 4, especially heinous, cruel, or depraved manner. The defendant committed the offense of murder in the first degree in an especially heinous, cruel, or depraved manner. And the final bracket reads as follows. Alleged aggravating factor number 5, lying in wait or from ambush. The defendant committed the offense of murder in the first degree while lying in wait or from ambush. And then there's a place there for the foreperson to sign in case the jury determines that he should complete Part B of the verdict form for that count. Sentencing hearing, Phase 1 verdict form, count 9, murder in the first degree after deliberation, Veronica Mosher Sullivan. Part A, Section 1, we the jury do unanimously find that the prosecution has proven beyond a reasonable doubt the existence of at least one of the alleged aggravating factors with respect to this count of murder in the first degree. And there's a space there for the foreperson to sign in case that's the jury's verdict. Section 2, we the jury do not unanimously find that the prosecution has proven beyond a reasonable doubt the existence of at least one of the alleged aggravating factors with respect to this count of murder in the first degree. Therefore, we the jury render a sentencing verdict of life imprisonment without the possibility of parole on this count. And there's a space there for the foreperson signature in case that's the jury's verdict. The asterisks read as follows. The single one says, if the jury unanimously finds that the prosecution has proven beyond a reasonable doubt the existence of at least one alleged aggravating factor with respect to this count, the foreperson should sign only on the designated line in Section 1 above. Section 2 above. The jury should then disregard Part B of this verdict form. Part B reads as follows. If the jury does not unanimously find that the prosecution has proven beyond a reasonable doubt the existence of at least one alleged aggravating factor with respect to this count, the jury should disregard this Part B. If, however, the jury does unanimously find that the prosecution has proven beyond a reasonable doubt the existence of at least one alleged aggravating factor with respect to this count, the jury must complete this Part B by having the foreperson mark with an X in ink the bracket or brackets next to the aggravating factor or factors. The jury unanimously finds the prosecution has proven beyond a reasonable doubt. The first bracket reads as follows: alleged aggravating factor number 1, 2 or more persons. The defendant unlawfully and intentionally and intentionally, knowingly, or with universal malice manifesting extreme indifference to the value of human life generally, killed 2 or more persons during the commission of the same criminal episode. The second bracket reads as follows: alleged aggravating factor number 2, intentionally killed a child under 12 years of age. The defendant intentionally killed a child who had not yet attained 12 years of age. The next bracket, the third bracket, reads as follows: alleged aggravating factor number 3, created a grave risk of death to another person in addition to the 12 victims of the crimes of murder in the first degree. In the commission of the offense of murder in the first degree, the defendant knowingly created a grave risk of death to another person in addition to the 12 victims of the crimes of murder in the first degree. Fourth bracket reads as follows: alleged aggravating factor number 4, especially heinous, cruel, or depraved manner. The defendant committed the offense of murder in the first degree in an especially heinous, cruel, or depraved manner. The fifth and final bracket reads as follows: alleged aggravating factor number 5, lying in wait or from ambush. The defendant committed the offense of murder in the first degree while lying in wait or from ambush, and then there is a space there for the foreperson to sign in case the jury determines that it should complete Part B of the verdict form for that count. Just a few things. We're going to take a break here in just a moment because we've been at this for over an hour now. And what I propose, if it's okay with everyone, is taking a short 10-minute break or so, 10, 15-minute break, bringing you back in at that point, and have the attorneys do their closing arguments, their arguments. I have limited each side to 40 minutes, and then at that point, we would let you start deliberating, at least those of you who are deliberating jurors. The alternates will be kept separate, and the alternates will not be allowed to deliberate. Same rules as before apply. And then we'll bring lunch to you. We'll have lunch brought to you, and lunch will be brought for everyone, even if you're not deliberating. And then the deliberating jurors can deliberate while they're eating lunch if they wish. They don't have to do that, but they can do that if they wish, as long as they follow all my admonishments. We will have all the exhibits available in the jury room where the jury will be deliberating. That's jury room for courtroom 201, with the exception of those exhibits that you're not allowed to consider in phase 1 of the sentencing hearing. Remember that I've given you an instruction that the deliberating jurors during their deliberations cannot consider any evidence that was admitted for the limited purpose of considering the issues raised by the defendant's plea of not guilty by reason of insanity. So that applies not only to the testimony, but to all evidence, including any exhibits that were admitted for that limited purpose. Does everyone understand that? And everyone's saying yes and not in their head yes. I know that all of you still have your copies of the jury instructions that I gave you at the end of the trial. And I know that some of you may have taken notes on those instructions, and I told you that you could do that. We're not going to ask for those copies back, but what I am going to ask is that you not consult those instructions. Even if you're not a deliberating juror, even if you're an alternate juror, let's have all of you not go back to those instructions and read them or review them for any reason, all right? So I've given you a new set of instructions that applies to phase 1. That's what we just went over right now. The original set of instructions is stamped original, and we'll go back to the deliberations room. And then we have the original verdict forms, and they too will go back to the deliberations room. Please don't make any markings on the original instructions and the original verdict forms. You can mark all you want on your copies of the jury instructions that I just gave you and on your copies of the sample verdict forms that I just read, but no markings should appear on the original set of instructions, and the only markings that should appear on the original verdict forms is where the foreperson indicates the jury's sentencing decisions in phase one. Does that make sense to everyone? Yes, everyone's saying yes and nodding their head yes. At least some of you are. Next is, there are no limits on deliberation. So the jury takes as little or as long as the jury wants. One thing that's going to be different is there's not going to be a 3-hour delay once the jury reaches its sentencing verdicts. We'll wait 20 minutes. So instead of the 3 hours that we did at the end of the trial, all right? And then the final thing is, and there are 3 things here. Throughout the proceedings, I have been giving you an admonishment that tells you that you cannot be exposed to any news reports in any way related to this case. And so I want to make sure that you understand that to the extent that in the past you have been exposed to any media or news reports related to the case, even if inadvertently, and even if despite your best efforts, then let my bailiffs know that you need to talk to me about something. Similarly, if that happens in the future, same thing, right? Even if inadvertently or despite your best efforts at some point in the future, you're exposed to some information related to the case or anything related to the case from a news report or a media report, please tell one of my bailiffs that you need to talk to me. Another admonishment that I have been giving you is that that you cannot visit any locations that are mentioned in the trial. Same type of admonishment. If at any point in the past you have inadvertently visited a location that has been mentioned in the trial, even despite your best efforts, or if that happens in the future, inadvertently, even if inadvertently, and even if despite your best efforts, let one of my bailiffs know that you need to talk to me about something. And that's all you need to tell my staff, my bailiffs, is that you need to talk about something. And finally, if at any point in the past or at any point in the past you have inadvertently seen or received any outside information concerning the case from any source, or if at any point in the future that were to happen, even if despite your best efforts and even if inadvertently, let my bailiffs know that you need to talk to me about something, and then we'll take it up here in the courtroom. Does everyone understand all that? And everyone's saying yes and nodding their head yes. Great. Okay, with that then, folks, let's go ahead and take a break. It's hard to take 10 minutes with so many of you, but let's do our best to take 15 minutes if we can, and then we'll proceed with closing arguments. I should ask you, is that okay with everyone? It's going to mean that you're going to get lunch a little bit later than usual. Is anybody not okay with that? Is anybody who's not okay with that proposal? No, nobody's raising their hand. Great. I very much appreciate your attitude, folks. Thank you. Please make sure you follow all my admonishments during the break. They all apply. Oh, I was wondering what you were doing. The record should reflect that the jury has exited the courtroom. Please be seated, everyone. Is there anything we need to talk about at this time on behalf of the people, Mr. Orman?
Thank you.
Anything we need to talk about on behalf of the defense, Ms. Brady? Okay, great. We'll be on break. Thank you. I'll see you in 15 minutes. Court will be in recess.